Hello, everyone, and welcome to today's webinar. We're delighted to have you with us. And we truly appreciate your attendance, especially we have people joining from different time zones today. My name is Jay Cohen. I'm a partner at Tilleke Gibbins, and I head our Cambodia office. It's my pleasure to welcome you today to our webinar entitled Understanding U.S. Sanctions Compliance and Their Impact on Cambodia and Southeast Asia. I'm also delighted to be joined by our friend from Steptoe, Meredith Rathbone. She is a partner at Steptoe and has deep experience in U.S. sanctions, export controls, and international regulatory matters. We're really grateful to have her join us today and share her insights on this really timely and evolving topic. Before we begin, I'd like to just mention some basic housekeeping rules for today's webinar. One, today's webinar will be recorded. All participants are currently on mute to minimize background noise. Please feel free to submit your questions at any time through the Q&A box or the chat function. We will get to those questions at the end of the session. And we will be addressing all these questions at the end of the session. At the end of the webinar, also there will be a QR code on the screen. Please take a moment to scan it and provide your feedback on today's session so that we can improve future programs. So for today's webinar, just to let you know about the format, Meredith will provide a brief presentation, which will be followed by a discussion on sanctions between me and Meredith. And then we'll also have a Q&A session where we'll be answering your questions on sanctions and compliance issues. So before I hand the floor to Meredith, I just want to address the origin of this webinar and how it grew out of the sanctions designation by OFAC of the Prince Group. Also, I mentioned that while we understand that the Prince Group has retained legal counsel to challenge this designation, they're still on the sanctions list. So as a result, many businesses in Cambodia and abroad, they have an urgent need to understand their compliance obligations in relation to U.S. sanctions and the Prince Group and other sanctioned entities and persons. At the same time, we want to recognize that the issue of sanctions is not unique to Cambodia or the Prince Group, and businesses operating international will likely confront sanctioned persons or entities from time to time. Therefore, it's really important to understand what your compliance obligations are and how either you as a foreign company should handle this situation or how you as a U.S. company or U.S. person should handle this situation. Therefore, we hope, by the end of this webinar, you'll have a better understanding of your compliance obligations and how to handle these sorts of situations. So with that said, I'm going to turn the floor over to Meredith.
All right, great. Thank you so much, Jay, and thanks to Tilleke for inviting me to participate in this, and thanks to everybody for joining. We thought we would start with me just giving a bit of an overview of the structure of U.S. sanctions so that everybody's kind of on the same page as to how they're structured, and then we can talk through a bit more how they apply in particular circumstances. So maybe if we move to the next slide. There's our agenda. Okay, we can move to the next slide. And one more after that. There we go. Okay, perfect. So U.S. sanctions, for the most part, are administered by OFAC, which is the Office of Foreign Assets Control at the U.S. Treasury Department. And there's a link, or you can see there the website for OFAC, and they do publish guidance on their website. They have a lot of frequently asked questions. Their website is, there's a section of their website that you can go into that's broken down by country. There's also, depending on the sanctions, not all sanctions programs are country focused. So sometimes they're focused on human rights violations or things like that. So in that same section, you'll see other types of non-country based programs. And then they also have a page, and there's the address there, where they have a sanctions list service where you can go and you can search the OFAC sanctions list to see if a particular entity that you're dealing with or considering dealing with is on the sanctions list. So they do have a good bit of information on their website if you take the time to have a look at it. In addition, just from a list perspective, because I know a lot of what we'll be talking about today relates to parties that have been sanctioned on the SDN list, which is the list of specially designated nationals and blocked persons. But anyway, there are other sanctions lists apart from the SDN list, and there's another government agency called the International Trade Administration that has a consolidated list. So when I'm searching to see if a party is sanctioned, I usually go to that list because it has not only the SDN list, but it also has other lists that OFAC maintains and then some that other US government agencies maintain. So those are helpful tools. One thing to keep in mind is that those lists only contain the names of the entities that have been specifically added to the SDN list or whatever other list they're on. It does not contain the names of entities that are treated as sanctioned because they're majority owned by one or more SDNs under the 50% rule. And we'll talk about that a little bit more, but I just wanted to mention that so that you're aware. We can go to the next slide. So there are a few different types of sanctions programs that the US government has. You can kind of put them into a few different buckets. One are the comprehensive sanctions, and those are really country-focused sanctions programs that target places like Iran and Cuba, North Korea, Crimea, and essentially US persons are restricted from doing business with those countries or engaging in most types of dealings with those countries. The specifics, vary depending on the particular country, but those are very broad restricted programs. And as I'm sure many of the people participating in this webinar recall, the US government used to have a program that was almost a fully comprehensive sanctions program targeting Myanmar. And that was rolled back several years ago. Certain new sanctions have been put on Myanmar, but they're not nearly as strong as what they were previously. So there's comprehensive sanctions, which are targeting a handful of particular countries. Then there are list-based sanctions programs. And when we talk about SDNs, we're talking about those types of programs where the US government identifies particular people or entities and adds them to the SDN list. And once somebody is added to the SDN list, US persons generally cannot deal with SDNs directly or indirectly, and they can't deal with the property or interest in property of SDNs. If they have some property or interest in property of an SDN that comes within the United States or within the possession or control of a US person, such as a US bank, for example, they're required to block that property. So I'm sure many of you have heard about situations in which a bank has frozen funds and refused to process a transaction. That's the reason, oftentimes. So those are pretty broad restrictions, and they apply to dealings with SDNs directly or indirectly. And then there are, as I mentioned earlier, various other types of lists that have somewhat different restrictions on them. Sometimes you can deal with parties who are on one of these different lists in certain ways, but not others. And we won't go into the details of that today, but just know that if a party is on a sanctions list or an export controls list, it doesn't necessarily mean that they're subject to these full blocking prohibitions. You have to look at the type of list. And then there are the third bucket of sanctions programs are what we call the hybrid sanctions programs, or sometimes they're called sectoral sanctions programs. Those are the types of sanctions the US government has on Russia and Venezuela at the moment, where it's not completely prohibited to do business with those countries or with entities in those countries. But there are a lot of restrictions, for example, new debt, granting new debt to entities in those countries, or importing oil or energy, and various other types of restrictions. again, in the interest of time, we won't go into the details on those today, but it's to be comprehensive, we include that in the list. We can go to the next slide. So OFAC sanctions, US sanctions they do tend to be quite extraterritorial in their effect. They do impact people all around the world, but there are some important distinctions to understand regarding how US jurisdiction applies. So for most sanctions programs, those apply to US persons. We call those the primary sanctions. So those are the regulations that make it prohibited to deal with an SDN or to deal with Iran or Cuba. Those apply to US persons as a technical matter, which means they apply to US companies. They apply to the branch offices of US companies that are operating abroad, and that comes into play quite a bit with banks because many banks have their non-US entities structured as branches rather than as separately incorporated entities. They apply to citizens and to lawful permanent residents, also often called green card holders, wherever they're located in the world. So a US citizen or permanent resident who is working in Cambodia or any other country will still be subject to the scope of the US sanctions. And then if there's a non-US person and they're physically located in the United States, the sanctions would apply to them there as well. In addition to that, it's possible that non-US persons can also become subject to US sanctions if they cause a US person to violate the law, or if they take some action involving a US jurisdictional nexus, they can get swept into the scope of these sanctions programs. And there have been a lot of enforcement actions brought against non-US companies for violations of the US primary sanctions. There are some sanctions programs like Cuba and Iran that also apply to non-US companies that are owned or controlled by US persons. That is not the case for most of the SDN sanctions regimes, so we won't spend too much time on that. And then there are the secondary sanctions, and these are the ones that really tend to have the ability to impact non-US persons, because secondary sanctions, essentially what these are there programs set out by the US government to try to achieve certain national security or foreign policy goals of the United States. And they don't prohibit non-US persons from engaging in certain activity. It's not unlawful for a non-US person to engage in activity with an SDN, for example, if there's no US jurisdictional nexus there. However, these secondary sanctions are essentially structured to say, look, to non-US persons, we can't prohibit you from engaging in certain activity. We don't have jurisdiction over you to be able to do that. But what we can do is tell you that if you engage in certain activity, then it's possible that we could cut you off from US commercial and financial markets. That's the construct or the concept behind these secondary sanctions. And so the way that that works in practice is if a non-US person engages in certain types of activity with an SDN, for example, then it's possible that that non-US person could themselves be added to the SDN list. SDNs are not the only place where this concept of secondary sanctions comes up, but it's a significant one, and there are a lot of parties added to the SDN list pretty much weekly. for having engaged in some sort of support of an SDN. So that's what, when we talk about secondary sanctions, that's what we're talking about. And then the one other thing that I'll mention quickly is export controls. So if somebody is on the SDN list, or at least on the SDN list under most of the sanctions programs, including what's called the Transnational Criminal Organizations Program. That's the one that the Prince Group is designated under. If somebody's on the SDN list, then it's unlawful to provide them with items that are subject to U.S. export controls jurisdiction. So U.S. manufactured items or items manufactured outside of the United States that have sufficient U.S. origin content, exporting those to somebody who's an SDN in most cases would be prohibited. All right, next slide. Okay, in terms of enforcement, these sanctions laws are pretty actively enforced. There are regularly enforcement actions, and sometimes they are very significant enforcement actions. There have been some over the years, mainly against financial institutions, that have gone up to hundreds of millions, or even around $1 billion. Most enforcement actions are for smaller amounts, but there have been many quite significant ones as well. Criminal penalties can be a fine of up to $1 million and or imprisonment for up to 20 years. For something to be criminal, the party who's engaged in it has to be doing so in a knowing way. And then there are civil penalties with fines of up to, it's currently $377,000 roughly per violation, and that's an amount that goes up every year for inflation, or twice the value of the transaction, whichever is greater. And also the party engaged in the violation can lose their right to export. The government is quite adept at finding ways to charge more than one violation per a set of, over the course of some activity. So, for example, if you were to engage in a transaction with an SDN and were to process the payments in a way that that involved a U.S. bank, which is often the case when U.S. dollars are involved, then it is possible that those payments to the SDN could be, if there's more than one payment, even if you purchase one item, if you make 3 payments, that could be 3 violations, for example. So that's how the penalties can sometimes get quite high. And then for secondary sanctions, engaging in this, what we call sanctionable activity, like providing material support to an SDN, that can result, as I said earlier, in the non-US person getting added to the SDN list, which is probably the biggest restriction that they can impose. For banks, they can also have their US correspondent accounts terminated. There can be visa restrictions for individuals and sometimes even their families, so the US government won't issue a visa for them to travel to the United States, those types of things. There are various different sanctions that can be imposed, but the one that is used the most often is the addition to the SDN list. I think we can go to the next slide. And this is the last slide. Just to set the stage here for questions I know Jay will be asking. So earlier this year, OFAC designated the Prince Group and its CEO and various related persons and entities. They were alleged by the US government to operate online investment scams targeting Americans, among others. The Prince Group, of course, is a very large and prominent group in Cambodia and has all sorts of investments in, the legitimate industries as well, which I know presents quite a few challenges for companies operating in the country and elsewhere in the region for that matter. They were sanctioned, I mentioned earlier, they were sanctioned under a sanctions program that's not a country-focused sanctions program. It's a different one called the Transnational Criminal Organization Sanctions Program, TCO. Was also coordinated with UK authorities who imposed some of their own restrictions, and then also coordinated with the US Department of Justice, which is bringing criminal charges against the chairman of the Prince Holding Group. So that I know has resulted in a lot of questions by companies in the region. And maybe with that, I can hand it over to you, Jay, to talk through some of the types of questions that may arise.
Yeah, thank you so much for that presentation, Meredith. So yeah, now we're just going to talk through a couple of issues related to sanctions before we open it up to the audience for Q&A. So the first question I have, I mean, as you noted, the U.S. government maintains a list of sanctions on the OFAC website, and there's like a number of different sanctions programs, such as the one that you just mentioned for transnational criminal organizations. But there's other sanctions programs, and then there's sanctioned programs targeting specific countries, like you mentioned, like Cuba, North Korea, and Iran. So my question is, regardless of the sanctions program, if a person or company is placed on the SDN list for specially designated nationals and blocked persons, are the sanctions the same on that person and entity, or does it depend upon what program they're sanctioned under?
Yeah, so for the most part, the sanctions are generally the same, which is that U.S. persons cannot engage in activities involving blocked persons. That's what one of the phrases used to refer to people on the SDN list. So U.S. persons can't engage, directly or indirectly involving blocked persons or their property. And non-U.S. persons risk being designated themselves if they provide material support to these SDNs. One area where there sometimes can be some difference is that the U.S. government does issue from time to time what they call general licenses. So these are kind of authorizations that they'll publish on their website that permit certain types of activity with certain types of SDNs. So, for example, it's in some instances, as was the case with the Prince Group, there was a wind down general license that was published for a while that enabled people to kind of wind down business with designated entities. There are certain other types of general licenses that OFAC issues in other circumstances. And so it's if you do find yourself, dealing with an SDN in some way, it's good to take a look at those general licenses to see if there are any that might cover your activity. The general licenses technically only apply to the primary sanctions. They apply to the activities of U.S. persons. But for the most part, under the secondary sanctions programs, if a non-U.S. person is engaged in activity that would be covered under a general license, if they were a U.S. person, then typically the U.S. government will not designate them, it won't add them to the SDN list for engaging in that activity if there's a general license that would cover the scope.
Okay, yeah, thank you. That's very clear. And then also during your presentation, you mentioned like the OFAC's 50% rule. And can you just like clarify again, like sort of the importance of that? Because as I sort of understand, you can look at the SDN list and see who's on it, but that's not the end of your analysis. how does the 50% rule sort of interact with the SDN list?
Yeah, so the 50% rule, basically what that is, it's a rule. So as I said, US persons are prohibited from dealing with SDNs and with their property and interests in property. And so this 50% rule is really kind of a way to get at whether something is considered the property or interest in property of an SDN. And if an SDN is determined, well, if an SDN owns 50% or more of an entity, or sometimes it can be a combination of SDNs, two SDNs owning 25% each. If they own 50% or more of an entity, then that entity is considered blocked. It's basically treated like an SDN, even if it's not listed on any list. That certainly creates a real challenge for companies because there are restrictions on parties that don't even appear on a list. But that is how the 50% rule functions. One thing I will mention is that there is one fairly unique circumstance relevant to Cambodia. So last year, another Cambodian group, LYP, was designated. And when that happened, OFAC issued a general license stating that it's not prohibited for US persons to deal with entities that are 50% or more owned by the LYP group, but that are not specifically listed on the SDN list. In other words, the 50% rule, because of this general license, currently doesn't apply in that specific circumstance. They have not done the same with the Prince Group. And these general licenses, they can be revoked at any time. So sometimes the US government is concerned about unintended consequences, especially for companies that play a particularly critical role in a country's economy or a certain sector of that economy. And so sometimes they will issue general licenses for a period of time, but then later revoke them. So that could change going forward, but that is a pretty unique general license relating to the 50% rule.
Okay, yeah, that's very interesting. And I can see it really sort of like deepens the analysis of trying to understand like who you can and cannot interact with.
Yeah.
Along those lines, from the perspective of a sanctioned person or entity, especially if you're overseas, what are the implications of being placed on the SDN list?
Well, it's a real challenge. You don't ever want to wake up one day and see your name on the list because it does immediately, based on what I've seen, create a lot of headaches for companies. A lot of counterparties will stop dealings with them, either for fear of actually violating the law or for fear of being placed on the SDN list. A lot of banks will refuse to process transactions for the same reasons. A lot of banks will actually freeze accounts or just offboard, the SDN. If US persons are involved, they would become prohibited from dealing with the sanctioned person or the sanctioned entity. As I said earlier, if they have property of that sanctioned person or entity in their possession, they have to block that and file a report with OFAC. So, for example, if an SDN has sold something to a US entity, and the US entity now owes them payment, they can't make that payment. They have to block the funds and put them in a blocked account. So those are some of the challenges. For non-US entities, there are challenges as well, especially for any US dollar transactions that are cleared through a US bank. If an SDN has an interest in those transactions, then the US bank, the clearing bank, has an obligation to block the transaction and freeze it. If the non-US entity initiating the transaction does not tell the US bank about the interest of the SDN, and the US bank goes ahead and processes that transaction, then the non-US entity could be violating US law by causing a violation by the bank. And there have been a lot of enforcement actions for that, for basically hiding the interest of a non-US entity, or sorry, of a sanctioned party in a banking transaction. I've seen situations where companies added to the SDN list have suddenly had their access to their certain software programs like Microsoft Outlook or Word or Excel frozen. Their licenses to use the software products have been revoked, and then they're scrambling to try to access their records and things like that. So that's another thing that can happen. And then I mentioned earlier, under US export controls, once somebody's added to the SDN list, under most sanctions programs, it's unlawful to export any items that are subject to US export controls jurisdiction to them. So yeah, there are a lot of complications that pretty quickly come about.
Yeah, I could say it would put obviously companies in a very challenging situation to be placed on an SDN list. Turning, I know on this call there's a lot of foreign companies, or probably most of the people on the call are non-US based, non-US person companies. So I think the question I would like to ask then is, where are these companies most likely to encounter secondary sanctions exposure if there's no clear US nexus? And what kind of due diligence should they be doing to sort of mitigate the risk of tripping over these secondary sanctions?
Yeah. So it's most, as a technical matter, most types of transactions within SDN will carry some risk of secondary sanctions. So it's hard when you're dealing with an SDN. It's hard to get to zero risk, unless there's a general license or something else that specifically carves out a certain scope of activity or carves out activity for a certain period of time. So it's hard to get to zero risk. That said, OFAC has a lot of discretion in deciding who to add to the SDN list, and they certainly don't add every single person or entity around the world that deals with an SDN to the SDN list. So they do engage in some decision making about when they're going to choose to do that. The risks, I would say, tend to be higher for situations where the activity that somebody is engaging in is linked to the reason for the SDN designation. So, if somebody is alleged to be engaged in, I don't know, the shipment of Iranian oil, then engaging in activity relating to the shipment of Iranian oil would be higher risk. If somebody's alleged to be engaged in, as the Prince Group was, this kind of fraudulent activity, then engaging in activity in support of that would be higher risk. The higher the value and the volume of activity, the higher the risk, I would say. So if it's, involves a lot of money, or if it's kind of a regular, recurring, ongoing activity, the risk is bigger. Any activity kind of designed to hide something or cover something up also tends to be higher risk. And, then there are certain types of activities that are maybe higher risk because they're more likely to come to the attention of US authorities. The shipping industry is an industry that the US government monitors very carefully, for example. Banking is another one. So there are, there are certain activities that are maybe more likely to be more prominent, or to be, seen by the U.S. authorities. It's really a case by case assessment. So, for example, if somebody's got a long-term lease to rent I don't know, a small restaurant in a building that's owned by an SDN, then that is a risk. Like I said, it's hard to get to zero risk, but that's, I would say, a lower risk than entering into a new contract to construct a new building for an SDN that could be used to further whatever activity it is that they've alleged to have done. So, OFAC does have some criteria that they set out that talks through these types of things, but in the end, they have a great amount of flexibility to be able to determine when to add somebody to the SDN list. And when they do that, it's very often without warning. Sometimes companies can be added to the SDN list because, OFAC has seen paperwork that, has their name on a transaction involving an SDN. And even if it was a small amount of a company's business, it's still possible that, something gets in front of OFAC, they deem it to be worthy of enforcement in that way. And then, you wake up and find yourself on the SDN list.
So to me, that sounds like actually, is this also an area where, like, if you're a foreign company and you have certain like commercial transactions with like an SDN and blocked person, if you're wondering whether your activities are a high risk activity, which could get you subject to secondary sanctions or could get you on the SDN list yourself, or whether it's really a low risk activity, would that be actually an area where foreign companies might get legal advice to see like how their activity might be viewed by U.S. authorities?
Yeah, it is, and it is an area where non-U.S. companies, tend to regularly seek U.S. advice for purposes of sanctions compliance, just to understand what is their risk. Sometimes they're in a situation where they're already engaged in the activity and there are risks regardless of what they do. And just trying to make sure that whatever they do is done in a compliant way that doesn't actually violate the U.S. primary sanctions, and then also, their next steps reduce their risk as much as possible under the secondary sanctions.
Okay, and then by reducing risk, I mean, one of the questions is like, if a foreign company is engaging with like an SDN or a blocked person, like in terms of reducing risk, do you mean winding down the transactions, trying to like terminate the commercial relationship, things like that? Would that be sort of a suggestion to sort of reduce risk?
Yeah, exactly. So precisely that, where possible, winding down the transaction, trying to terminate the relationship. It's, again, it's doing that is not necessarily zero risk, but a lot of times companies find themselves in a situation where they have to do something because they're already engaged in dealings with an SDN, and they just have to figure out what's the best approach. Do they wind down the transaction, and if payments are owed to a sanctioned party, do they make those payments, or do they freeze them in a blocked account? And if they do that, they also need to balance the risks, the commercial risks, for example, of having the blocked party bring a lawsuit against them.
Okay, for breach of contract. So I mean,
for
there's
breach
that
of contract,
risk.
exactly,
Okay.
that happens sometimes. So there are these various different risks that parties need to weigh, and how somebody proceeds really, I think, very much depends on the specific circumstances.
And then following along those lines, in addition to engaging in commercial transactions, what would you recommend in cases where someone on the SDN list has actually invested in your company, perhaps owned shares in your company, if they own 50% or more, we understand that your entity would also be on the SDN list or would be considered a blocked person. But what happens if they own like a minority interest in your company? They've invested in your company. They own less than 50%. What kinds of things would you recommend in that situation? Or what kind of analysis should the company think about in terms of how they should now handle this situation?
Yeah, well, if they own, as you said, if they own greater than 50% of the shares, then your company will be treated as a block company. There have been circumstances where the sanctioned party then divests to below 50%, and then the company is not treated as a blocked party anymore. So that's definitely something to think about if a sanctioned person owns greater than 50%. If that's the case, any property that has already been blocked, it's going to stay blocked. You know, if it's in the possession or control of a U.S. person, they would need a license to release it. But then going forward, activity wouldn't be prohibited. But if the sanctioned person owns less than 50%, it's kind of I'd say important to look holistically at the situation. So, for example, you know, what proportion of the shares do they own? Do they own 5%? Do they own 49%? You know, your counterparties may view their risk differently depending on the percentage that they own. It may also depend on what type of business it is. You know, is it a business that's somehow supporting the activity that the sanctioned person is alleged to be involved in? Is there a way to bring about the divestment? If there is any sort of a U.S. nexus, it's really important to get legal advice to determine whether there's any sort of an obligation to block that investment. You know, in other words, you may need a license to divest. But if there's not a U.S. nexus, there's probably not a prohibition on divesting. So it's a complicated situation, and your counterparties, your banks, and you know other businesses that you deal with very often will look at that investment and think about whether that brings about any additional risks, because entities, you know, in which blocked persons, SDNs, have an interest, a significant interest, but less than 50%, are relatively more likely to themselves be added to the sanctions list, even if there's less than a 50% ownership. So a lot of times, you know, counterparties will be more hesitant to deal with those types of entities, as opposed to a situation where an SDN may have a 5% ownership interest.
Yeah, I can say, very, very sort of challenging situation for those companies. Another sort of situation I think companies might face, particularly here in Cambodia, where you know many companies might have had commercial relations with members of the Prince Group. Like, how should companies or banks, how should they handle things like legacy receivables, payables, or litigation claims? I mean, where you've perhaps done work for a sanctioned, a blocked person, they owe you money. Can you accept money from them for the services that you already performed? Or if they have other debts, can they settle their debts to you? Or because now they're on the SDN list, for some reason, you can no longer accept their payments going forward?
Yeah, so part of that depends on whether the U.S. primary sanctions apply. So if there's a U.S. nexus to the transaction, like if you are a U.S. person or your company is a U.S. person, you know, then it would be prohibited typically to accept payment for prior activity involving the sanctioned person. So if they owe you money, usually you would have to get a license to be able to be paid, or you know, be paid within the scope of the wind down license if OFAC has issued a wind down license. to pay similarly, if you're a U.S. person or there's a U.S. nexus and you're paying the sanctioned party, if you owe them money, also that's something that would require a license. And even if there's a wind down license, usually that also requires that the funds be paid into a blocked account.
Okay, so then even like if a sanctioned person they perform services for you, you want to pay them, you would also need that license.
Usually you have to usually there's under the wind down licenses, most of them, you're not able to transfer money to the blocked party. So if there's a U.S. nexus involved, then dealings would be prohibited unless there's a license, either a specific license that you apply for and receive or a general license. But for activity outside the scope of U.S. jurisdiction, that's where this kind of, secondary sanctions risk analysis comes into play. And I would say for the most part, if you have performed services for an SDN, particularly if they're legitimate services, legitimate business activities, especially if they're not supporting the alleged problematic activity of the SDN, then you are permitted to get paid. You could, I take that back. Permitted is the wrong word, but receiving payment for that pre-SDN designation activity is probably not, it's lower risk. Making a payment to the SDN, a significant payment, especially if it's a large one to the SDN, is, I would say, higher risk. Probably will depend on the specific circumstances and what the payment is for and things like that. But making a payment to an SDN is higher risk in that, there may be a greater likelihood that you yourself wind up on the SDN list as a result of having done that. But it's not necessarily illegal under U.S. law to do that if there's no U.S. nexus. It's possible that banks would block those transactions or freeze those transactions or reject those transactions. It's very common for banks to not proceed with transactions involving SDNs, even if it's not unlawful for them to do that. So that's something we see quite a bit. But yeah, those SDN designations do create really a lot of headaches and a lot of messiness around what do you do when you're in the middle of some type of a transaction or payment cycle.
Yeah, thank you. I'm going to ask us a couple more questions, and then I'm going to open it up. I know some members of the audience have also asked some questions. So just a couple of final questions. One, do you have any sort of recommendations for companies? Should they be inserting any clauses in their commercial agreements to help kind of protect them or insulate them from situations where their counterparty is sanctioned in the future?
Yeah, it's a great idea if you can, to negotiate some sanctions language into contracts. And there are a couple of important things. One is to have a sanctions clause that talks about violations of U.S. law and also, by the way, non-U.S. sanctions as well. It's usually these clauses are broader than just U.S. sanctions because, of course, a number of countries have their own sanctions programs, as does the United Nations. But so you can include language that the contract is void, or you have the option to void the contract if proceeding would create a violation of applicable sanctions regimes. But then the other thing to keep in mind when you're negotiating these sanctions provisions is that, as we talked about, the secondary sanctions regime does not result technically in a violation of U.S. law. That's violations occur under the primary sanctions regime. Under the secondary sanctions regime, that's not violative activity, it's sanctionable activity. And so when you're negotiating these types of contractual provisions, it's important to include language that's a little bit broader, that gives you the discretion to not proceed with a transaction if doing so exposes a party to sanctions risk. And most contracts that I see, after the fact, unfortunately don't have that broader language in them. And so then for parties who are outside of US jurisdiction, where their activity wouldn't violate US law, it would just risk subjecting them to secondary sanctions. A lot of times that can make their contractual arguments weaker. So having that additional language is helpful if you can include it.
Yeah, thank you. I know there's a couple of lawyers on the call, so hopefully they'll be thinking about that when they start drafting their own contracts. Just two more quick questions before I open it up to everyone to some of the questions. The first one is, if a person is being sanctioned or they're put on the SDN list and they feel it's unwarranted, is there a process for them to try to get off of it? I mean, could they engage you or another firm to help them get off that list?
Yeah, so there is a process for delisting. You basically go to OFAC, you file a delisting petition. You can also, do outreach to OFAC beyond that, although they do tend to be quite busy given the number of SDNs and parties trying to come off the list. But yes, there is a process for doing that. It is really, really important to, in most cases, to not rush into that process and to make sure that you've taken the time to really carefully think through OFAC's allegations and what you can say about those, whether it's that, yes, we were engaged in that activity, but we've stopped, or no, we weren't engaged in that activity, and here's why we think you may have a misunderstanding, or whatever the case may be. But it's really, really important that those submissions are credible and that they're accurate. As soon as you include information in those submissions that turns out to be inaccurate, you can lose credibility and significantly reduce your chances of successfully coming off of the SDN list. So it's important to make sure that you engage in that process in a very forthcoming and thoughtful way. It's in most cases, with very few exceptions, for example, where OFAC clearly designated the wrong person or company by accident, for example. But in most cases, it's a slow process. It takes many months or a year or even more than a year to work your way through this OFAC process. And so it's unfortunately for most SDNs, it's not going to happen quickly, but there is a way to try to seek delisting.
Okay, great. Thank you. And then the last question, when would you recommend that, particularly foreign companies, when might they need legal advice regarding U.S. sanctions? When maybe should they come and see you if they're confronting issues here in Cambodia or elsewhere?
Yeah, it's certainly anytime you are have found yourself in a situation where you're dealing with or potentially would be dealing with a sanctioned party or a sanctioned country. If you're in a situation where you're really not sure, what the best way is to extract yourself from that situation, and you need some guidance about how to do it lawfully, it's important to get legal advice, because there are a lot of ways to violate the sanctions laws are in some ways, intuitive, and in some ways pretty complicated and there are a lot of nuances to them. And you'll just, always want to make sure that, your next steps are the most compliant and the least risky as possible.
Okay, yeah, thank you. Well, hopefully, for people on the call, that might give you some thoughts of like when you might need some legal assistance with these sorts of issues. So yeah, thank you so much. I think now we can kind of turn. I can see we have like a number of like questions people have asked. So if you don't mind, we'll turn to some of those questions and yeah, see if we can answer them. So one of the first questions is, I know you sort of talked about if an SDN entity has invested less than 50%, if an SDN entity has invested in your company and they hold less than 50% of the shares, then you are saying that the company will not necessarily face sanctions because the SDN has invested less than 50% of the shares. But what about, will there be any sort of exposure of like the shareholder who holds more than 51% of the shares, but that person's not a US citizen, they're a foreigner. So is there some sort of risk for the other shareholder in this company who's not the SDN, who has a majority of the shares? Do you see risks in that situation?
Yes. There is some risk there. So, as like I said earlier, when you're dealing with an SDN, it's really hard to get to zero risk. So if you have a situation where, you have an SDN that has 49% of the shares and you have 51, I would say that is a relatively higher risk situation because there's a greater likelihood that OFAC could look at that. If it were to come to their attention, they could learn about the shareholding percentage and they could view, the company as, even though not owned by an SDN, a company in which an SDN has a very significant interest. And so there is a possibility that the company itself could be designated. There's also a possibility that the individual shareholder could be designated. OFAC does sometimes designate shareholders or CEOs or other people within a company, particularly if they think that person in that company are engaged somehow in supporting the activity that is the reason for the SDN designation.
Okay, so like
yeah.
if it's related to say like human trafficking or romance investment scams, that'd be high risk. But if the business is involved in maybe restaurants, hotels, hospitality, something unrelated to the reason for the sanction, then probably a lower risk kind of situation.
Yeah, I would say that would be lower risk, maybe not zero risk, because OFAC, in many cases, will allege that those otherwise legitimate business activities are used to launder the illicit money from the problematic activities. And so, it's not necessarily the case that those other types of activities are low risk, but on the gradation of risk, they are probably lower risk than supporting the highly problematic activities. And then I would say that the risk is lower as well if the shareholding is lower. So 49% versus 4%, the risk is lower if the SDN has 4%.
Okay, thank you. That's quite helpful. A couple questions that I see are a little bit related that people are asking. One has to do is like if you're a service provider in say Cambodia or another country, and you provide just services to end users, could be internet, software, video games, like just normal services. Do you need to screen your customers to make sure you don't provide services to people on an SDN list?
Yeah. So if there is any sort of a US nexus to what you're doing, then yes, I would highly recommend that you screen, because it's possible that you could violate the law if you're providing software that's subject to U.S. export controls jurisdiction. And by the way, a lot of software manufactured or made outside the United States is subject to U.S. export controls jurisdiction because it pulls in certain software that's at its core U.S. origin and incorporates that into non-U.S. origin software, for example. So if you're providing, software, technology, goods that could have a U.S. nexus, it's a very good idea to screen. The same with services, software is offered typically under a license. And so, as I said previously, I've seen situations in which SDNs had their access to Microsoft turned off and those types of things. So if you're a distributor or reseller, those types of things could get problematic. If you are engaged in providing a service to an SDN that is not subject to U.S. jurisdiction, then there's this secondary sanctions risk. And it is, I think, a good idea to screen so that you know who you're dealing with and you know whether you're subjecting yourself to some sort of a secondary sanctions risk. I would say that what that risk is really going to depend a lot on what you're doing. Like if you're, I don't know, an electricity provider, right? And you provide electricity to half the country. And this is, in the grand scheme of things, a very small customer of yours. And there are government requirements that electricity service providers, can't discriminate or something like that. Then that type of situation is a lower risk than if you're providing, services to help an SDN ship products that they're not supposed to be shipping or something like that.
Okay, thank you. Another sort of related question, maybe a little bit of a different side of that. If the SDN is a bank, for example, and you're a customer at that bank, and you're a U.S. person, can you get in trouble for interacting with the bank? So if like the bank is now an SDN, you have a customer account with the bank, or you want to use the bank to transfer money abroad or back to the U.S., by virtue of using the bank, which is an SDN, can you have legal issues? In particular, if you're a U.S. person?
Mm-hmm. Unfortunately, yes. Using the bank would typically require a license from OFAC. So normally, and that would be a situation where I think it would be a good idea to try to get a license, if at all possible. If there's a wind down period and you're able to, withdraw your money and close your account within the scope of the wind down period, that's ideal. But otherwise, that's a situation where you could request a license. And by the way, if there are a lot of U.S. persons in the same circumstance, it may be an opportunity to go to OFAC and see if they would be willing to issue a general license to enable people to, terminate their accounts.
Okay, thank you. Meredith, I know we're already at 5:03, so we're already running a little bit like overtime. So unfortunately, I'll say to other people on the call, we won't be able to answer all of your questions now. But if you do have any further questions, please email. I can see in the chat group or in the chat, we have an email address, events@tilleke.com. So if you send any further questions there, we're happy to answer those for you. I just really want to thank Meredith for taking the time today to speak with us and to share her expertise on this really important and timely topic in Cambodia. So Meredith, thank you so much for joining us today. And please also, if anybody has any questions, please contact me or Meredith.